YNW Melly just got a major victory in court. You see, the prosecutors are using evidence from YNW phone and his social media accounts. That's the majority of their evidence, since there's really no tangible or physical evidence of YNW Melly that connects him to the murder. So they pulled up some Snapchat videos that showed YNW Melly throwing up gang signs and with a pistol. But here's the thing, the prosecutor's motive for this is that YNW Melly killed his two friends for furtherance of a gang. So when they pulled up the Snapchat video, that's to prove that YNW Melly is in a gang and that YNW Melly is actually a weapons owner, and also further incriminating video evidence. Well, YNW Melly lawyer was not letting that slide, and he objected.
Your Honor, our first objection would be relevance. I think Florida statute 9401 defines relevance as evidence tending to prove or disprove a material fact. There was not a single video that you witnessed there that implicates in any way any fact and issue in this case.
His first objection was relevance. Now, here's why that's important. Because the Snapchat videos they're trying to play is Snapchat videos of YNW Melly acting like a goon, acting like a thug, acting rowdy, acting like a juvenile. Essentially, man, you feel me? He got the blunts out. He got the pistols out. You feel me, man? Sagging his pants. He's cussing. He's stacking up the gang signs. He's acting like a real one, like a real ninja. You feel me? All right? So the defense is like, hold up now, bro. Like, him stacking up gang signs, all right? Him sagging his pants, right? Him acting like a juvenile, rolling the blunt, got the pistols in hand. That has nothing to do with whether or not he murdered his two friends. And the only reason they're bringing this up is so they can slander his character. Because this is the game here. When you come to court, when the court sees YNW Melly acting like an innocent child, right, with the suit on, looking real shy and smug and looking around, the jurors are looking at him as if, yo, he's a kid, he's innocent, right? Not innocent in terms of did he do it? No, but innocent in terms of, yo, he's just a little kid. But the prosecutors want the jurors to ignore his youthful stature and to view him as a menace. And that's their purpose of bringing up the Snapchat videos, is so the jurors can view YNW Melly as an utter menace.
The fact is, unless I'm missing something, there is nothing there that concerns the events of October the 26th, 2018, in any way. As far as the messages are concerned, it's similar.
Now we're talking about what's in writing, correct?
What's in writing is essentially a dump from that account, a selective dump, I think from August the 3rd through some date in November. If the state is indicating that there are messages there that relate to the offense, then the state should isolate those messages and make its argument as to what the relevance of those statements is or are.
This is why it's really important to have a real crafty veteran lawyer, because they're both super slick. See, the prosecutors are slick and the defense attorney is also slick. You see, what the prosecutors try to do is they try to highlight some messages, right? Like, for example, when he would call his girlfriend on the night of the murder, he called his girlfriend and he wrote her, right? So the prosecutors have some messages or some instances that are relevant. So they're trying to use that to kind of say, you know what, yo, listen, Your Honor, these messages here are relevant. We know he called his girlfriend via Snapchat. These is relevant, so let's allow everything in. And the lawyer like, hold up now, bro. Nah, hold up. That's not how this works. Yes, there are some things that may be relevant on Snapchat via messages, right, that he sent that may be incriminating or, you know, that may relate to this trial. But we have to highlight those individually. We just can't say because he used Snapchat to incriminate himself on certain situations that means that y'all can just allow everything from his Snapchat to come into evidence. That's not how this works.
But to suggest that you can just dump all statements that somebody makes since birth until the time of their trial, and because it's non-hearsay because it's a statement of the defendant. And by the way, these are exchanges, so a relevancy of, objection, or sorry, a hearsay objection relates to the statements of the defendant, not the ones that are made back to him in any kind of conversational exchange. Those statements themselves are hearsay because they aren't statements of the defendant. And I'm making this argument assuming, because I'm dealing with relevancy, assuming that those statements are indeed statements of the defendant, which I'm not conceding. They have to have some relevance to this trial and facts in issue at this trial.
I feel like the fight that he's talking about is going to happen later on, but they're more than likely going to lose that particular fight in terms of if the prosecutors do bring, I guess, relevant messages or do bring things that do apply to the particular case, right, that is relevant. If they bring those messages in, they're going to lose the fight trying to argue that there's no way to prove that YNW Melly is the one who wrote this. Because there are contextual things that, does provide context to, listen, it's nobody else, right? It's nobody else writing these messages but YNW Melly, right? So if they're trying to fight that is not him writing those messages from his personal Snapchat account that he's had for years, they're going to lose that fight, I believe.
So each statement the state would have to establish the relevance of each statement in isolation prior to it being admitted into evidence, saying these are all from his phone and therefore they're all his statements and this is a business record exception and therefore they get in, doesn't cut it. As far as authenticity is concerned.
Right, so that's the objection to the relevancy. But he's also fighting the prosecutors on the authenticity, I should say, right? I'm sorry, people, right? Of the Snapchat messages and video and audio, right? So essentially he's saying, listen, all right, y'all can't prove it's relevant, but we also have to prove these messages, these videos, these audios are authentic. So he's about to cite another case and their standards for verifying that a screenshot or a video or an audio is authentic. Now, what's happening right now, and if y'all haven't caught on yet, right, is the prosecutors are bringing in YNW Melly's girlfriend mother and a few other witnesses, and they're trying to ambush the witnesses and the defense with the screenshot messages just in case, his girlfriend mother, try to veer away from exactly what she told them or what she verified to them, early into the investigation. Because early into the investigation, YNW Melly's girlfriend and her mother was talking to the prosecutors, and they was talking. Now, I got another video coming soon when the mother says that, the prosecutors intimidated her to speak, right? But nonetheless, though, they're trying to say this is not authentic, or y'all have to at least prove the messages are authentic, and they're about to cite another case to prove why the prosecutors have a higher level of burden than the one they're already working with in terms of proving the messages are authentic.
In that case, there was concern regarding the admission of screenshots of text messages, communications. And the court said it was okay because there was a witness that testified that she was sitting next to the defendant in a car when the texts were made. And the detective recovered a cell phone from the defendant, and the witness identified the text messages between her and the defendant. In other words, there was a party to the communication who was able to authenticate the communication and who the participants are. Another case is Roy, which is 279 Southern 3rd 238.
279 what?
Southern 3rd 238, which concerns emails and texts. And these were emails that were admitted through the investigator that was posing as a 14-year-old in what appears to be a case that concerns some sort of a pedophile sting. And the investigator involved in the exchange, the investigator was involved in the exchange in the emails of the text. One of the quotes that I took from that case says, most common way to identify social media, which would be this, and things akin to social media, is to let the author testify that they're the ones who generated or created it. So there's somebody that is involved in the exchange of the communication that can attest to the fact that they created it or were involved in it and identify the parties that were involved in the exchange. When a participant is used to authenticate electronic exchange, the focus is on the witness's ability to identify the person against whom the communication is offered. In criminal cases, the person communicating with the target of the investigation must be able to identify the target through some personal knowledge or experience. So this establishes that there has to be somebody who participated in the communication, who authenticates the participants in the exchange, and must be able to identify the participants in the exchange.
YNW Melly is in good hands. The defense attorney was cooking. Now, the prosecutors had a turn. I'll be real. If you look at both exchanges between the defense and the prosecutors when they were talking to the judge, the prosecutors looked like, they were amateurs, man. I'm just being real, right? They looked, they came off as amateurs, don't know what they're doing, discombobulated, incompetent, nincompoops. All right, so the prosecutor spoke to the judge, and this is her reasoning for why the Snapchat evidence should be admitted.
Your Honor. Specifically, authentication for the purpose of admission is a relatively low threshold that only requires a prima facie showing that the proper evidence is authentic. I'm reading on the 9th page of notes 5 and 6. Your Honor. Lamb case goes on to state that authentication for the purpose of admission is the ultimate determination of authenticity of the evidence is a question for the fact finder. Evidence may be authenticated by appearance, content, substance, internal patterns, or other distinctive characteristics taken in conjunction with the circumstances. In addition, the evidence may be authenticated either by using extrinsic evidence or by showing that it meets the requirements for self-authentication. With regards to the evidence that's before Your Honor, the defense is not agreeing that it's his account. So then the burden is on the state to prove that it's his account. As such, the evidence itself shows that it's authentic, as it is the defendant in every single one of those videos. In terms of the contents of the defendant's statements, they are relevant. They go to the issue and fact of whether or not he committed these two homicides. The contents of the questions are important for giving context.
After both sides went back and forth and argued their particular point as to why they believe the evidence should be admissible or not admissible, the judge made a ruling. And YNW Melly got a slight victory today because the judge denied the prosecutors the ability to use the Snapchat videos and audio and evidence that she wanted to use from Snapchat. He denied her the use of those evidences today in court when she was questioning the witnesses, right? So YNW Melly's girlfriend mother was testifying today, and the judge denied the prosecutors access to use the Snapchat evidence during the cross-examination or during the direct examination. But that's just for today. So it looks like the prosecutor's plan backfired because every night the prosecutors are supposed to tell the defense who the witnesses are for the next day and who they plan on calling, et cetera, and the evidence being admitted. But they didn't do so that night, and that was the only night they didn't do so during the trial so far. So which means they planned on ambushing the defense, hoping the defense wouldn't have a proper retort to block the evidence from being admitted. Those plans backfired. Now they can't use it at all. All right, so y'all let me know in the comment section, man, what y'all think about this, man. Who do you guys think is winning this case so far? Is it free Melly or keep Melly? It's your boy, Poetic Flacco. I'm out of here, folks. Peace.